Senator Bacik, you have 10 minutes.
I'd like to welcome Minister Fitzgerald to the House and very much welcome the introduction of this legislation. And I know it's already gone through the Dáil, and you've referred, Minister, to some of the amendments made in the Dáil. It is a long-awaited bill, and I'm glad, as others have said, that you've stressed the urgency with which it's being brought forward, and that we all hope that it will be, or not all of us clearly, but some of us hope it will be brought into law before the summer. And as you said yourself, the members of the Commission designate are also very keen to see it brought into force. You've also mentioned the key events that the government, to which the government is committed, such as the marriage equality referendum in spring of next year. I think it's vital that we have the sort of statutory framework set out here for a human rights body in advance of that referendum. I must say, I think it's extraordinary that Fianna Fáil are opposing it. I hadn't realised in my innocence that they were going to take this view. It's particularly extraordinary, given their history on this. I wrote some years ago, around the time that, and Senator Donovan has kindly reminded us of that around the time Minister Dermot Ahern, former Minister Dermot Ahern, made 43% cuts to the Equality Authority budget in 2008. I wrote at the time that a very quiet coup was taking place, and that the Equality Authority was being very much undermined by the then government. And I just wanted, others have paid tribute rightly to Maurice Manning, the former President of the Human Rights Commission. I want to pay tribute to Neil Crowley, the former Director of the Equality Authority, who played a huge role in promotion of equality issues and protection of equality, and in taking groundbreaking cases. And I utterly reject my friend and colleague Senator Conway's critique of the Equality Authority in the Portmarnock Golf Club case. It's easy to just dismiss that as a misguided case, given the outcome. That outcome in the Supreme Court, many of us disagree fundamentally with the reasoning of the Supreme Court judgment. It certainly wasn't necessarily a predictable outcome, and I think that they were quite entitled, and indeed quite entitled to take that case. I had done a study some years ago with colleagues on gender discrimination in the legal profession. We found golf clubs to be a really significant site of discrimination for women working in the legal professions, who are being excluded from golf outings and therefore excluded from the sort of client solicitor gatherings that would bring in money and would enhance their reputation in the firm and so on. So there's a lot of, it's easy to just dismiss golf clubs as elitist. I would actually agree with Senator Conway on that entirely. But I do think that the sort of action taken by the Equality Authority, it wasn't just a kind of a populist action. I think it was an important action in terms of trying to promote the rights of women and promote rights of women to be equal members in very influential and large institutions like that golf club. Anyway, I wanted to return to the bill itself and to say that I think it is vital that we move forward with the new merged body to ensure that it can be as effective as possible in the protection and promotion of both equality and of human rights. The Justice Committee, as others have said, have conducted hearings on the bill, and we indeed had members of the Commission designate in before us. And I do think, as Senator Zappone has very eloquently outlined, I do think it's hugely important that we would continue that strong interaction between the Justice Committee and the new entity, the merged entity. And I think that, and I'm glad that the aspects of the independence of the Commission and indeed of its links to the Oireachtas have been highlighted and strengthened in this bill. The Justice Committee, indeed, at an initiative from Senator Zappone, is looking at adding human rights to our title, so that we would have specific jurisdiction to deal with human rights issues as well as equality issues and justice issues. I think that we've got very useful observations before us from the Council for Civil Irish Council for Civil Liberties and indeed the Human Rights and Equality Commission designate, and I've read those carefully in terms of really trying to analyse the bill and look and see the sort of the aspects of it that we need to highlight both at second stage and of course at committee and report stage. And there's some key themes in the bill. I mean, the first theme I really wanted to speak on was the definition of equality and human rights. And I'm glad, as the NGOs have said, that there's no definition of equality in the bill, and that it's appropriate that is left undefined. But I note the difficulties between the two definitions of human rights that have been highlighted both by Senator Zappone today, but also by the observations of the ICCL and the Human Rights and Equality Commission designate. There is a narrow definition of human rights in Section 29, in the part of the bill dealing with enforcement and compliance. But I think in some ways that's simply a practical issue, because, and I'm just trying to get my head around it, because I absolutely agree in principle with the idea of, I agree in principle with the idea that yes, the broader definition in Section 2 should be there, particularly for the work of promotion and advocacy around human rights for a Commission. But I can see a practical difficulty if a Commission is trying to hold bodies, either private or public, within the state to account by reference to a set of human rights standards that are not contained in the Constitution or in any international treaty or the European Convention on Human Rights to which the state is a party. I think there could be a problem. And I know the Human Rights Commission say that you'd still have to, even if you use the wider definition of human rights more extensively in Part 3, you'd still have to exclude certain provisions. You couldn't, for example, have compliance notices. And they say here, they recommend the wider definition be used, save for Section 41 and Sections 36 to 39, noting that those functions could only relate to law that is enforceable. So I think that they do, however, recommend a wider definition be used in other parts, in other sections of Part 3. And I wonder, is there a middle ground that could be devised here? Because I can see there could be a practical difficulty with extending it throughout all of the provisions of Part 3. But that's one issue of the definition. In terms of the second issue of the actual establishment of the new Commission itself, as I've said, I think the independence is a hugely important issue. Section 9 gives us a guarantee of that. The funding issue has been very much highlighted, and the fact that the Commission must have adequate resourcing in order to be effective. And of course, as I say, we've seen that from the history of the rather controversial history around the Equality Authority and in particular. So, it is very welcome that we saw the amendment made, I think it was an amendment made at the committee stage in the Dáil, to make in Section 21, to make the Director the accounting officer for the vote of the Commission. So the Commission will now have its own vote. And I understand, as you said, Minister, administrative arrangements for this are in train. I think that's hugely important because that was a real issue in the observations produced on the first published version of the bill by the Commission and by the ICCL as well. So that's important. The third theme really is the issue of enforcement, and again an amendment you didn't refer to but I think it was important was just to the title of Part 3, which was originally just enforcement and is now enforcement and compliance, and that was something the Human Rights Commission designated recommended because it is a more accurate depiction of the wide range of provisions contained in Section 30 in Part 3. And I wanted to just refer here to three different aspects of Part 3, then you've highlighted some of them, Minister. First, the codes of practice issue. As you've said, the Sexual Harassment Code is a really good example of the sort of important promotional work that bodies can do in seeking to ensure compliance with human rights standards. So I hope we'll see more of that under Section 31. Section 35 and the power to conduct an inquiry. Now, there's been some recommendations from the ICCL and the Human Rights Commission designate that there should be some changes made. But I must say this, I looked very carefully at the wording in Section 35. I know we'll be going into this more in committee stage, but I do think it's of particular significance now, just in the wake of the report Judge John Cook produced into the GSOC bugging allegations, because in his recommendations, Judge Cook actually devoted quite a significant part to his recommendations on the public interest inquiry power of GSOC. And he says one of the problems, and it really was highlighted in the political controversy around those allegations earlier this year, but one of the problems was the lack of specificity of criteria as to when GSOC could conduct a public interest inquiry. So I think Section 35, it's hugely important that we have very specific criteria here. I think it's hugely important to see that the Commission may conduct an inquiry of its own volition, so it doesn't have to wait for a ministerial request, but also, if you look carefully at the wording as I see it, that even if they are requested by the Minister, they don't have to do it. They may conduct an inquiry if the Commission considers, and so on, and then the criteria are set out. So, I think this is the sort of power of the Commission that, in the previous legislation was there, but was never really, not really practicable to use. This, I think, is a much more practicable section. I don't think it's a power that should be exercised lightly, or indeed will be exercised lightly, but I do think it's hugely important that the initiative is left to the Commission and that the criteria are very clearly spelled out for the Commission, and indeed that the procedures are set out in Schedule 2. So I'm really pleased to see that, and I just think the GSOC example is an important one of where we're not specific enough, and where we set out power to conduct a public interest inquiry, that can run into problems. The final thing on Part 3 is just to talk about Section 42 and the new provision, and I just really wanted to welcome this. The new provision, which was promised in the programme for government, has been looked for by different NGOs. And this is the public sector duty now that a public body in the performance of its functions should have regard to the need for equality and human rights protection. I think that's hugely important. And again, just at the Justice Committee this morning, we heard some really impressive examples of work that's been done currently in the Defence Forces by Commandant Jane Lawler, who is the Gender Equality Officer there, and the very practical way in which she has begun to ensure that gender equality is not just an aspiration within the Defence Forces, but becomes a reality. Inserting, for example, a requirement that people at every stage of promotion would receive some gender training, some equality training. Requiring, for example, that before anyone goes on a tour of duty abroad, that they would receive training on gender-based violence and so on. And some very practical examples of how Irish troops abroad serving with the UN have made life safer for women and girls going outside of camps to collect water and so on, just recognising the need to ensure protection. So really impressive examples in practice of how this positive duty on public bodies can be implemented. So I think Section 42 is hugely important. I want to finish just by the one other point I wanted to make was Section 54 in Part 5, and I do very much again welcome this new enforceable right to compensation if there's judicial error in terms of deprivation of liberty. I must say the DG case, when I was in practice, I was one of the practitioners who was acting in cases in which juveniles were detained following the precedent in DG. Many of us very troubled by that, but as you know, Minister, it was used often where her parents were begging us for some way of ensuring a child's safety. So it was very problematic, and very glad to see that we now have remedied the issue that was addressed in the European Court of Human Rights decision. So I think this merger has been a long time in the making. I think most of us are very keen to see this bill come into being. I'm very disappointed it's going to be opposed. I must say, I just assumed somewhat naively we might have a cross-party consensus on this, because it's so fundamentally a good thing. Yes, there are bits in it we can tweak and we can discuss, but it's absolutely imperative that we have a statutory framework for our national human rights and equality body. Thank you.